All right. Good afternoon, everyone. This is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for January 15th of 2024. Brad, go ahead. Take
Very
us
good.
away.
Well, a good Martin Luther King Day to everybody. First, we're going to start out in Phoenix, and this is more up your alley. So I don't know how much of this you want to take, but this is pretty
I'm
impressive.
happy to do it if you want. I got my administrative crap out of the way here. But yeah,
Sure, sure. Take it.
it's an FLSA claim, and it's a rather unusual one. It's not the typical type of case we see. But we've got a captain who is assigned to, I'm assuming like he's an EMS supervisor, or maybe he's the safety officer, but it's a
The
unit
infection
designated.
control officer or something.
Yeah, and I mean they're big enough that they might need just an infection control officer on shift or whatever it may be. But he's assigned to this unit C959. And he apparently was dealing with a firefighter who had some sort of an infectious disease exposure, which, depending on the nature of the exposure, requires a lot of follow-up. And there's liaisoning with the hospital and the doctors. And it's important because depending on what the source patient has, there may be certain requirements now that the firefighter take certain medications immediately, that if you wait too long, there can be complications. So this is very time sensitive. At any rate, the officer put in for 12 hours of overtime because the incident started, I think, at 7 o'clock at night or whatever, and then followed through 6:15 at night until 7 o'clock the next morning. Apparently, he was no longer on shift at that point, but he put in for overtime, and the department only paid him 5.5 hours. So he put in for overtime. Apparently, that was turned down, and they gave him 5.5 hours. They didn't give him 12.75 that he requested. He filed a grievance, and then subsequently, according to him, he was transferred. And he's claiming that the transfer was retaliation.
Because it's a demotion, right? I think you report it's viewed as a demotion.
That's what and there's also the perception, a stature in the organization. So again, a lot of details. I got to tell you, I don't get it. I just don't get it. And the reason,
Which part of it?
I've got a lot of friends that are in the Phoenix Fire Department. If there's any country, any department in the country, there's really goes above and beyond to try to accommodate their employees, it's Phoenix. And so that's sort of number one, sort of red flag in my mind. Number two is I know their attorneys. They have some of the best attorneys on staff to defend fire departmes.
Except
and
that they're losing, aren't they? I mean,
they've actually hired attorneys with experience defending firefighters to work for the city of Phoenix in their law department. So they're squared away, and I find it kind of hard to believe that this has kind of gotten to this point. But here's the other point. Okay, people don't file suits in federal court over 7.5 hours of overtime.
Right.
There has to be more to what's going on than what's in the complaint. I've got to believe. Now, that may favor the plaintiff, it may favor the department. But I'm just, and there's, in my opinion, there's two types of lawsuits that you can walk into an attorney's office and they're going to take on a contingency. One is a personal injury. Okay, and that's sort of, we get a bad reputation for taking virtually any personal injury case that comes in. The other one, if you go to an attorney that handles FLSA cases, is an FLSA case. Right. But even that, most FLSA attorneys don't want to take a 7.25 hour overtime case.
Except that they're starting from a advantage point here because the Department of Labor there already ruled in favor of the employee against, right? Which doesn't always mean everything, but it's very persuasive. And they're starting out saying, we already got the Department of Labor saying the department's wrong. When I read this and started thinking, my God, he wants, the difference of 7.5 hours, just pay him the damn thing. Why, or the guy, or discipline him for putting in false time, right? One or the other. Here, they don't do either, which to me is what's something's weird with this, because I get why the attorney's taking it, thinking, hey, we get our fees paid, right? Who cares what it is? And we already got a DOL, opinion in our favor, so let's sue it out. They must really believe he was being retaliated against, because that's where this money's coming in, not over 7 hours of, and what's going to be $100,000 of lawyer time here.
Seriously. I mean, to think about it, to take a case to federal court, and especially if you end up going to trial, you're talking $200,000 easy.
Yep.
Over seven and a quarter hours of overtime.
Demotion. They really, well, I presume, have to believe there's a demotion that took place.
Yeah,
or demotion-like activity.
Right, exactly, and that he's no longer in that prestigious position, and now he's in a different position, and so on. So, I don't know. I guess we'll see. But it's a very unusual FLSA case. Next month we're going to be doing our FLSA class in Georgetown, Texas, and we're going to be talking about cases that involve dozens of firefighters, if not in some cases hundreds of firefighters. Those are the much more common ones. And in that case, if you have hundreds of firefighters that each got improperly paid 7.25 hours, now it starts to make a little sense that you're going to have $200,000 worth of lawyers' fees because you've got hundreds of people involved. We just don't. My point. We just don't see cases like this. This is the red herring. We don't usually see FLSA cases like this.
And like you said, the department's probably not a persistent violator. But here's the other part that I thought was missing. I kept thinking I'm going to turn the page and see, and they went back and found this was a common practice going on for 20 years. Right to your point. Thus, we're going to have a massive amount of hours. But this guy, I don't know how long he's been in the position. I don't know how many times he's had to do overtime, but it's not like they said you get no overtime. So that's also a little strange. Did he do the work in violation of some procedure? Was he denied it? What, did he not do the extra hours? You're right. Something is weird over this, but nonetheless, there's a lot missing from the allegations, like you have a history of doing this. And to your point, Phoenix probably does not. But I think it's the retaliation that got the attention of the lawyers to say retaliation's better money.
It is. And, we see this in sexual harassment and race discrimination cases as well, that sometimes the plaintiff loses the merits of the case on discrimination, but wins on retaliation. And the retaliation is a function of the fact that people are upset that they filed the suit or made the allegations or whatever it may be, and they take some sort of steps that harm the person, and you've got retaliation. So you lose your case, you lose your FLSA case, but you win on retaliation, or you lose your sexual harassment case and you win on retaliation. And I actually have a slide that I use in my presentations. It's of the caveman attorney from Saturday Night Live. And it's so easy a caveman attorney can win this case when there's retaliation. So, but again, you've got to prove it. But again, with retaliation, you don't have to prove you were right when you put in for overtime or whatever. All you got to do is show that you're retaliated against. So I don't know. We'll see. Another one of those we'll see.
Okay, let's go to Missouri. This I'm going to make a little shorter. It's here's what we had. We just had it's very specific to Missouri, and I would juxtapose this to other states many other states who have a defined benefit for the volunteer firefighters when they're injured. Missouri, on the other hand, has it's kind of a test, and it goes through a 2 or 3 part options of what you could receive, and the minimum you could receive is $40 per work week. So here's what we have. We have a firefighter who was killed in the line of duty, and he's a volunteer. We're talking volunteers, and he was killed in a rollover in 2018. So look how long this has been going on, right? Which is horrible that it's been going on this long. Nonetheless, under Missouri law, the surviving spouse of a volunteer firefighter who's killed in the line of duty is entitled to benefits. And the question in this case was, what amount of benefits? So they said, well, he has no, he's a volunteer, has no real work week. And so we're going to give him the statutory minimum of $40 an hour. And what the Court of Appeal and
$40 a week. $40
Oh,
a
wait,
week.
sorry.
Yeah,
Geez,
yeah,
$40 an hour would be pretty good.
yeah.
$40 a week. So, and this goes to an administrative hearing who agrees and gives the statutory minimum. And then the Missouri's Court of Appeals reverses and says no, which is a good holding. They said no. They said you have the right in Missouri as a volunteer firefighter killed in the line of duty to receive as a minimum, if you're unemployed or otherwise, the equivalent pay of a career firefighter in the area, which is an impressive amount of money. Normally, again, most states, New York, New Jersey, Maryland, I know a ton of states have a statutory amount for a death. You get X dollars, which, look, if you're make $1 million a year, it doesn't do diddly for you, right? But $40 a week, you've got to be kidding me. So the court gets it right. But all they do here, other than saying, well, here's what the pay is going to be, it's going to be the equivalent of a career firefighter in the area. We don't know what that is. They remand it back for that determination, but kudos to the court. They got it right. Better for the volunteers. The legislature in the state should take this up and correct the law consistent. And that often happens consistent with the court's holding to say, this is what we intended. And hopefully it's not the $40 a week minimum, because that would be hard.
I got an interesting question after I posted the story. I think it was on LinkedIn. One of the folks that he's a regular, reader of our material, and he asked, does the firefighters department pay workers' comp insurance? And it's an interesting question, because if they do, then they may be paying at a lower rate, like reading the statute the way that the trial court had read it, and now they're going to get hit. And I think that that's probably not the big question here. Okay, because what we're talking about is one thing to have workers' comp for an injury. It's a different thing to have a death benefit. And the death benefit in Missouri anyway it's a statutory, like workers' comp, but it's statutory and is pretty clearly based, though, when you read the decision, you compare it to the language, it's pretty clearly based on what a full-time paid employee would be getting, even if it's a volunteer. So it's a statutory thing, and that's going to it may burden the insurance company, but I think many municipalities are self-insured, or they have some sort of a policy where, and I know Providence was very much like this on most of their things, they had an insurance company or some sort of provider that would pay the actual amount out, and then there'd be a surcharge on it for their administrative overhead. So whatever you paid out in lawyers' fees and all the different fees, plus an administrative overhead for their work in managing the claims. I think that there's a number of municipalities out there that handle it. So the bottom line is it's going to fall on the municipality, possibly on the insurance company. They will have to make that up going forward to figure it out. But again, I agree with you. I think the court got it right. Hopefully that's going to be the end of it. I guess it could go up to the Missouri Supreme Court. Yeah, I know. And then, unfortunately, sometimes this becomes a political football and we get a political decision, which, isn't necessarily in anybody's best interest either. So, but who knows?
Okay. Next, we're going to go to West Virginia. This is one of those, and I got to be careful because it's a little bit of allegations, a little bit of findings. So, but I'll say allegedly. But if this is all allegedly true, I cannot believe this firefighter, and I'll get the facts, of course, is appealing or doing any of this. I always say to clients, when you are accused of doing something stupid or illegal, it's one thing, it's within your department if it's just disciplinary. The moment you sue, when your name is on a top of a case, now it's forever, right, public, and hence we're reporting on it. It's public information. So here we have a West Virginia, he's a fire lieutenant. He was terminated after 3 or so off-duty altercations. And he, the court here, again, ultimately is going to uphold the terminations, but it's what he's accused of doing. Now, listen, I get why they appeal. So what happens is the wife, I think, or the woman makes allegations and then recants them, goes back on them and says, well, maybe I was wrong, or that's not, what I said or whatever. And the question here is more of interest to attorneys because it's a procedural question. is when the court takes up the review of what happened at the lower levels, does the court review the case de novo as if it was the first court looking at it? Does it review it as an appellate court, which would then say, okay, we're not going to change the facts. We're going to accept the facts as determined by the trial level or by the lower level. And so how do we do it? And what's the burden of proof? Here, the highest level court here that held this issue or addressed it, the circuit court or the court of appeals, sorry. The Court of Appeals says, look, I'm going to say we view it as whether there was sufficient evidence, substantial evidence at the lower level, and we don't have to accept as true what was said. We can review it de novo effectively. We could take a new look at it. And they do. And what they look at, this is what gets me. So that's the procedural stuff, right, of interest to the attorneys. But I'm shocked. This guy is accused of holding a knife, all right, at superiors and making threats to them, accused of domestic abuse, accused of all these things, right? And I'll go through some of them, but 2 arrests for domestic assault are the allegations. Disrespectful behavior towards Ms. Wilson and her mother, but when wielding a firearm, and and they expressed a fear for their safety. And then the firefighter told Mr. Morrison, I think that's I don't know if that's a commissioner or who that is, but that he was going to kill another individual while wielding steak knives. So these are, if I had done this and 3 separate allegations, I'm not sure I just accept the punishment and go away. And if this is true and the court finds it is, so this is not allegedly, but court finds you are true, why would you appeal that? Why would you challenge that all out of procedural? Oh, no, you should, you have to accept the facts of the trial court. I would have just let this go from the beginning, but some people want to do what they want to do.
Yeah, well, folks can read the decision to get the exact facts. They are very granular. There's a lot of detail in them, but there were 3 incidents, some involving a knife, some involving a firearm, some domestic. And I, just from my experience in representing plaintiffs and defendants in domestic cases early in my career, I don't do it now, but early in my career, emotions get the better of people sometimes and cause them to do things that they may later regret, but also make allegations, that may not be they may not square with reality. And so whether or not that's what's going on in the domestic, there was 2 of them domestic, but there was also a 3rd incident that was not a domestic that did involve a firearm. That
discharges firearm while driving.
That's concerning. That's really.
Oh, you don't find the steak knife threat concerning?
Yes, but I've just been around domestic cases enough to know that sometimes it's a little bit like the funny mirrors, the mirrors at the circus, sometimes things aren't always as they appear, but that other one is really concerning. So again, you just don't know. But I think when you start to stack up these incidents all over a relatively short period of time, you find yourself in a hole that I think you're right. It's better off just walk away. But maybe they're all untrue, and maybe this guy is just found himself in a really bad spot. Who knows? But
not a good situation. No, definitely not. And again, the whole question of law, other than the procedural, is was there just cause for his termination? Any one of these things would have been just cause if true. And just again, for the viewers, all we're doing is reading and saying, here's what was said. We're not saying it's true or not. You and I don't know. We weren't there, but the court said, we believe it. We believe it's true, even though the women recanted. Personally, I probably would have advised my client, do you really want to do this? And some clients do. Some clients are like, I don't care. I'm right. I'm clearing my name. And it doesn't always work out.
Right. Absolutely.
Okay, let's go to I hate this. Let's go to Nevada. Yet one more. You know, I was putting together a presentation you and I are doing on personal liability at my conference, and I got to personal liability, child pornography, right? And it's not really something you do in the performance of your duties, hopefully, but there's a lot of personal liability for firefighters. For some reason, they use the Wi-Fi in the firehouse, or they're looking at porn while at the firehouse, or they're soliciting people from the firehouse or in the firehouse, even worse. And here we have, and so what I found, I went back through your 3 years, just 3 years of the blog. There were 10 cases, something like 10 cases of child pornography, many of which you and I covered, and a lot that we didn't even cover, right? But I mean, and you've said that there's a huge number of firefighters who are pedophiles
right. There's a number of different, we kind of use the grouping of pedophiles, but there's some subcategories of, you know, some are prepubescent, some are postpubescent, but that like children who are minors. Okay. And somewhere my information that I got from who I consider to be a very reliable source in law enforcement is roughly 1 out of 40 adult men is under the big umbrella of a pedophile. 1 in 40 adult men. And when I lecture on this, I say, look, you either currently have had, or will have a pedophile. And I say that with a great deal of certainty. And it's a problem. And one of the reasons why we want to do things right and have a good squared away discipline system is because if we allow misconduct in the workplace, and you have a pedophile. So, you know, case in point, where you have an officer who's engaged in maybe bringing a girlfriend into the firehouse to have relations or something of that nature, and you have a pedophile that works for that officer, that pedophile may feel like that officer can't report me. I can do whatever I want, because if he reports me, I'm going to report him. So and you're almost in a blackmail situation. And that's what concerns me about why we need to have a good, strong discipline system. And I'm not talking about calling ticky-tack fouls or writing people up all the time about stuff, but we just got to make sure that we're doing things right, so that we're not in a position where if you have a pedophile, and you will have a pedophile, that person is not going to feel comfortable enough to start doing stuff in the firehouse.
And so now let's get into the facts with that background, because you're right. And there's information I'm missing, but let's throw this out and have the Fourth Amendment discussion, because so here's what happens. A Nevada firefighter, right, first is charged with 3 counts of possession of child pornography. It was on his phone, which was left, I think, in the bunk room or somewhere in the firehouse.
On his bed,
he left it on his bed, all right, of the firehouse. The police, now there's a big gap in here. So I'm jumping from he left it on his bed in the firehouse to the police obtained a search warrant for the phone. What happened in the middle? I don't think we know.
And you want to speculate? I mean, we can.
Sure, let's speculate. We're guessing.
I'm assuming there had to have been some sort of a picture on the phone, or it didn't lock, and someone picked it up and kind of opened it to see whose it was, and then saw the imagery. Right. I've got to assume it's one of those.
And I've had questions as I'm talking about this with some people. They say, well, and we could go all day with this, but could the fire department, let's assume an officer or somebody sees it, it's like, oh my God, right? This is improper. Could the fire department seize the phone, stick it in a bag, right? It's a Fourth Amendment violation. They're the government. Or would it be a Fourth Amendment violation? And then call the police and say, we seized this crime in progress, basically. We seized it. We didn't look at it, but here, right? You go get a search warrant, because they got a search warrant. Now, search warrants, you could get them in an hour if you need to, right? But somebody had to secure that phone or surprise the firefighter in such a way that it was still on his phone, and then they grabbed it from him. I don't know the answer to that.
I think the closer case is where the phone is in the possession of the firefighter, and you try to take it away from them. I think pretty clearly at that point you've got a Fourth Amendment issue. But where the phone is left out and it's in plain view and it has the imagery evident on it, you don't have to go into it. You don't have to.
It's not a search.
It's not a search, and now you're going to basically, especially particularly an officer in the workplace that sees something that shouldn't be there, drugs.
Right.
I mean, we're talking
Sure.
about a phone here, but let's say it's drugs. I mean, are you saying that I can't seize the drugs and hold it for the police? No. I mean, you see evidence, you see contraband, you can take possession of it and contact the police. I think another closer case is where, let's say a captain sees it, and then the firefighter walks back in and says, "Oh, give me my phone."
Right. Right.
And now you're back to that situation where taking it away from could be, but doesn't seem like that's what happened here. It seems like he left the phone. It was uncovered. Must have been something disturbing. They contact the police. The police get a search warrant. They search him. They
And they found
search
not only the phone, but a USB drive,
his
which is
locker. They
really,
did a search of his locker. Now, I'm not sure if the search warrant covered his locker or if they have a policy that allows the fire department to go into members' lockers. But this is a squared away fire department, by the way. I'm familiar with it. I've done some work with their firefighters, with their union, and with the department. And this is square. It's a metro squared away fire department.
so I think that, well, let me caution viewers. When we say you can seize the phone, right? And then now we're talking about a locker. That doesn't mean you can go into the locker unless you have a privacy policy that says we can go into the locker at any time, right? If you remove the privacy expectations, but do not just start opening people's lockers without a policy. I think you should have one, right? That says anything the fire department gives you is not protected, right? Email, passwords, whatever, laptop, not protected from confidentiality, turnout gear lockers, normal changing lockers, etc. But so please don't take, hey, there's no privacy right. You have a privacy right. You have an expectation unless you don't. And that's done by policy. On your personal devices in the firehouse, you may have a privacy right until, as you said, plain view, if that's the case, which it had to be plain view. Somebody had to know it and see it.
It had to be, because otherwise, I mean, if you find a phone in the firehouse and you call the police aren't going to say, "Oh, let's go get a search warrant to see what's on it." I mean,
Right.
first of all, they couldn't. There has to be probable cause to believe a crime has been committed and evidence of the crime exists in the place to be searched.
Right.
So there had to be some sort of imagery on it.
And I will tell you, because I know this, but if you use, and we've seen a couple of these cases, I think, if you use the Wi-Fi to access known child pornography sites, the FBI will catch you. The FBI will find out where it came from. They'll at least get back to the Wi-Fi of the firehouse. From there, they may have to find the IP of the phone or something like that, but they will catch you.
We've had firefighters caught exactly that way.
Yeah. So, I think as a policy lesson, again, to all the viewers, your privacy policy, which should destroy the expectations of privacy, right? No privacy in your lockers unless you want to give it, right? But should also say, and anything you utilize our Wi-Fi access for has zero expectation of privacy, which some places have said you don't really need to state that because it's not logical. Of course there isn't, but either way, stated anyway, you have no expectation of privacy on any of our computers, with any of our electronic devices, and certainly not using our Wi-Fi network. I had an instance not so unreasonably where somebody wanted to use the Wi-Fi, but they were smart. They said, okay, we're not going to use the Wi-Fi, but the defibrillators had their own telecommunication process, their own modem, and they accessed it in the defibrillators and went through that way. And so you couldn't, and it masked it somehow. They couldn't figure out who it was. I think they eventually did, but because the transmission of the 12 leads and everything and the diagnostics of these are often done by a modem. You got to have a modem in some way. And so it has its own, they linked in through that and started. I'm like, if you're so desperate to access child porn, what are you doing?
Really? And why can't they use the talents that it takes to do that for good instead of,
Right. Well, because creepy people will do creepy things. I mean, let's end it there, but that's okay. The one I think this is the most interesting case. I wish I had another hour. I wanted to do a lot on this, but this is great for so many reasons. And it's going to be so interesting to see how it happens. So let me tell you where we are. We have an LA County firefighter, the firefighter, and we have the widow suing on behalf of herself and the children, I think. And the firefighter died at a fire. Now, we have so many issues. This case is just so ripe for settlement, and it kind of did and kind of didn't. So here's what happens. They go to a house fire. The short is they go to a house fire and the firefighter dies from a heart attack, right? And I will throw this in as the tease till the end. He has illegal substances in his bloodstream.
It's like a bad law school. This is like a bad law school exam question.
It is.
You know what I mean?
But, right? It's all the issues. It is. There's so much ripe here, but we're not going to focus on that too much. I mean, we can, but nonetheless, the autopsy concludes he died of a heart attack unrelated to that. So the autopsy is pretty good, but that's not why we're here just yet. Why we're here is because, and this is taking me back to the Black Sunday cases in the Bronx, right? This is exactly that. We have an architect homeowner. The architect homeowner is alleged, all allegations, right, is alleged to have, without a permit and in violation of electrical codes and other electrical practices and fire mitigation requirements, the architect homeowner, the homeowner is an architect, designed it, didn't get a permit, arranged for the installation of all of these things, and they allege that based on the non-permitted, dangerous electrical hazard without all the required mitigation, right, no permitting, all that, that was the proximate cause of the fire, the direct cause of the fire. You even relate to the question of proximate cause, which I like a lot, but that was the direct cause of the fire. And as a result, under the non-firefighters rule, right, which says a firefighter can sue, when you have those statutes, a firefighter can sue the homeowner for causing their injuries. Now, normally we see that by, oh, you had an icy driveway, or your dog bit me, or you shot me when I walked up, or right, something that happened after the fire occurred. But here we have, no, your negligence, the reason I as a firefighter am suing you is because you did something illegal to your property. That was the direct cause of a fire. And because I had to go to the fire, I got injured. And something you said when we addressed this a couple of weeks ago, you're not suing them as a result of the fire is the normal case. You don't normally sue under the firefighters rule for what brought us there. Right? Hey, you had a stove fire, not, may have been your fault or not. I'm not suing you because you were negligent in the stove fire. I'm suing you because there was an unguarded stairway that I fell down, or a dangerous condition on your property when you silently invited me in to attack your stove fire. I got injured, right? But here it's exactly the opposite, which is what's so exciting and novel about this case. And I honestly, I got to tell you, as would everyone in the Black Sunday case, I hope they win. I hope the firefighter wins, but it is going to be a very tough case to say you did something that led to the fire, presumably, right? And because you altered your house in such a way that created a danger, then we're suing you. Now think about this. This would open up landlord exposure to everyone. You have a crack house. You have a hoarder house. You have because you're a hoarder, I got injured searching around your house, and I'm suing you because of that. Now that's a little easier because the hoarding didn't cause the fire, but but
even a candle, even somebody having a candle, right? You were negligent in having a candle. I mean, it
you smoked in bed.
Right. And this is really why
I think cause.
Yeah, and I think this is why courts have adopted the fireman's rule. This is one of those cases. So they're going to have to get over that somehow.
Yeah, and that's going to be that is tough, but even so, and I just want to repeat this because it goes back to what you said before a couple weeks ago. This is not our normal fireman's case, right? This case is what caused the fire, not what happened after the fire. And usually we're suing for what happened after the fire. I hope that the firefighter wins, not just because they were injured, but why else do we have permitting rules, right? Why else do we have codes? If we're not going to enforce them. They're still going to have
to connect, though. They're still going to have to connect that. Right. Because just the fact that they didn't get a permit doesn't mean that the installation was negligent.
Right.
Okay. So just, and again, that may actually be irrelevant.
And this is so hard.
And it's this, you're absolutely, it's such a rich case for lawyers here. Right. The other big issue in this case to me has to do with the allegations that the widow had against the fire department. And she initially brought claims against the fire department and said that you were negligent, you didn't have good command and control, there's no accountability, you lost them in the building, and yada, yada, yada. And the city ended up, was it 3.2 million? What did they?
2.95. 2.95 million.
2.95 million. So now, but now when you think about it now, she and her attorneys are arguing with the city. You're responsible. You're responsible. You're negligent. You're negligent. You're negligent. Right now, they got to jam on the brakes, do a 180, and then they got to say the same thing against the homeowner. You're negligent. You're negligent. You're negligent. And it wasn't the city.
Right.
It wasn't the fire department, it was you. And I actually question whether or not maybe some of the documentation, maybe some of the expert opinions that they've undoubtedly submitted to get that kind of a recovery may actually contradict their allegations in this case. Right. So it'll be interesting. I do wonder whether or not they're going to be able to, again, jam on the brakes, do a 180 and head off in the other direction without a problem.
Yeah. And I think most people think lawsuits are easy. One of this, this is going to be so much back and forth. This was the cause. Yeah, but you had the last chance, called the last chance doctrine. You had the last chance to avoid the injury. And yeah, but he had drugs in his system. Yeah, it's so hard. But the hardest part, I think, is, and our good friend Chip Comstock probably deals with this a lot of times, what's the cause of the fire? You have to prove right here, you've got to prove the cause of the fire, which is investigated by who? Most likely, I'm guessing, the fire department or the city, right? Mm-hmm. So it's a little self-serving. They're going to want to say, oh, it was them, the homeowner. So it's a little self-serving. And also, then you have to prove that it could have been avoided, right? That we could have avoided this had it been, it was that the improper electrical, the improper whatever wasn't the proximate cause of the fire. Well, they'll say it was, but they'd have to prove that's not enough. They have to prove, had it been installed correctly, it still wouldn't have happened, or that in fact it was installed negligently. I mean, that maybe it's easy based on how they did it. Maybe not. I don't know.
I don't think so. There's a big misunderstanding out there, and I kind of go back to the principle of like driving without a driver's license. If you're driving without a driver's license and you get in an accident, okay, the fact that you didn't have a driver's license is irrelevant. It's not. And the reason I say that is because people say, well, if you let your paramedic license lapse and you do something, you're going to be responsible. No, not necessarily. Okay. Right. Or if you do something that you're not certified to do, you're going to be responsible. No, not necessarily. In fact, it may even be irrelevant. Okay. And that's where this permit, that's why I mentioned that before. The permit may be irrelevant unless you can show that the lack of a permit caused the injury. That if they had gotten the permit. Now, maybe in this case they could, but I think that there's going to be an awful lot of mud wrestling going on, judicial mud wrestling, in depositions to try to establish that.
And I'll tell you what, expert witnesses, because this is what it's going to be. It's going to be an expert witness electrician versus an expert witness electrician, right? It's going to be whether whatever caused the fire was installed properly or not. And had it been installed in accordance with code, would that have stopped it? And you're going to get an expert over here, an expert over here, and the court's going to be like, I don't know, I got to figure it out, right? And there's a burden of proof. One expert has to be so much more right than the other expert. It's not easy. And whenever there's a battle of the experts, those are the cases I avoid. I got to tell you, normally if I have litigation with the battle of the experts, it's a total roll of the dice, because they're going to find an expert to say the opposite of what you said. All right. And I've had those cases where I'm like, where my expert's saying they're insane, they're nuts. I'm like, yeah, well, it's what the jury thinks. If they sound good, if they present well, whatever the jury thinks, if they believe Mr. Y versus you, Mrs. X, so I hate battle of the experts, and they have to go to trial. That's interesting. They either have to settle, but they're not right for summary judgment, for motion work, because there's a question of fact when you have two experts. And so this is going to trial, not likely settling, and lawyers believe they're experts. Lawyers probably shouldn't believe their clients, but they believe our experts. And when you have two opposing experts, the lawyers each believe they're experts. I don't know. This is going to be a very difficult case, but I just want to say again, I hope they win, and that if they're true, I hope the firefighters win, because truly or the family wins, because if truly there was a violation of code and there was non-permitted work and that did lead to the fire or cause of death, the fire service wants that stopped, right? Ever since Black Sunday and before, we want landlords and homeowners to stop chopping up their house and doing illegal things in violation of code, if that's what happened.
Yeah. Well, one more thing, and I included it in the post, was a comment by the homeowner. And I think this also goes to the heart of the fireman's rule, which I'm not a fan of the fireman's rule. The fireman's rule says you can't sue the homeowner and so on, okay? But here's the quote. It says, "I feel like I would have been better not to have called the fire department at all." And, while I agree with you that, I hope the firefighter, the widow of the firefighter who died, wins. We've got to be sensitive to that too, because if it becomes too much of a liability for people who want to call the fire department because they don't want to, they're losing their house. On top of that, they're going to find themselves embroiled in a lawsuit. People may be less willing to call the fire department. So,
it's a valid concern, because we saw that with heroin, right? Where a lot of states now have if you call 911 for a heroin overdose, we won't prosecute you. And if they find evidence of a crime at a heroin overdose related to the heroin overdose, they won't prosecute you. So, because we want you to call. And that's the same type of, I get that. But if they did something that led, right, as I said, if they violated code and it led to the death, there should be criminal liability to me. I just,
Well,
and by the way, the homeowner saying he's not going to call, at some point, somebody is going to call, because your house is going to be engulfed in fire. So at some point, somebody's going to call. We may only be saving the basement.
I'm just thinking the sentiment that we don't want people, when, there's smoke in the basement, you don't want somebody hesitating to call 911,
because they have an illegal something happening.
For whatever reason, we don't want them hesitating. And that is only going to leave us, if we wait until a neighbor calls, the fire is going to be that much more further involved, putting us in greater jeopardy. So,
on the other hand, you don't call the fire department and say goodbye to your insurance.
Yeah.
Right.
Yeah.
I mean, I can't imagine insurance companies are going to cover a
loss
when you refuse to call about a fire.
Increasing the risk, when you do something that increases the risk of loss, that's where they deny the claim. So
yeah, I mean, anyway, I feel horrible that we lose our lives for somebody else's alleged negligence. So.
Well, I think that's going to do it for this edition of Fire Law Roundup. Next week, I am in Clearwater, Florida, doing some training down there. So we're going to be a little bit late on next Monday. So a week from today, that'll be, what's the date there? The 22nd? Yeah, 22nd. What will probably kick off at about 3 o'clock instead of 1 o'clock on January 22nd. But we'll see you again next week. If you can support us, please click like, please share, please let your friends know. And we appreciate those of you who've listened all the way to the end.